Let me start with you first. In your capacity as a former governor, the orders yesterday by the Supreme Court are very, very explicit, very clear that the office of the governor cannot be used to thwart the course of lawmaking. That yes, the governor can advise reconsideration once, but if the bill is sent back to him a second time, then he has no choice or she has no choice but to give assent to such a bill.
See, in my view, as far as I have been able to see, it is not as if the Supreme Court has said something absolutely new. The governor always had that right to go over a bill which has been passed by the Assembly and thereafter give his assent or go into certain alternative methods. Now, among these alternative methods, one was sending it back for reconsideration with or without suggestion. The second one was to send it to the President for consideration or for analysis or whatever. I don't remember exactly the language which was used. And he could use his discretion in certain matters which are not material in the case that the Supreme Court decided. I'll give one example from my own experience, an experience that I had as the governor of Meghalaya. The Meghalaya Assembly, and that too unanimously, had passed a bill which was called the Meghalaya Resident Safety and Security Bill Amendment. According to that, the persons from outside Meghalaya coming into Meghalaya had to register themselves in the police station, failing which they would would be subject to certain penalties. Now, I went through the Constitution and very carefully and took legal opinion also formally and informally. And then finally I said that this is not a thing which is there on the state list. On the other hand, this is on the union list. So the Assembly cannot legislate on this question. And therefore, this is outside the frame of reference of the Assembly, and I cannot give it assent to it. But because the Constitution requires gives me a recourse to send it to the President, I am sending it, and then I sent it.
So, A. Saravanan of the DMK, there is state list, concurrent list and union list. Where there are matters that come in the concurrent list, why should the governor not have powers to decide? As Mr. Roy said, there was this example that he cited of a bill which he felt was not in the state list, and yet the legislature had passed that bill. He then referred that matter to the President for reconsideration. So there are many such instances that come up, bills that get passed which may not necessarily fall in the domain of the state legislature, or it could be constitutionally challenged whether it is falling in the domain of the state legislature. The governor has powers to ask for reconsideration of those bills.
Yeah. See, Zaka, the Supreme Court has admonished the governors, all the governors who have been appointed by the BJP, especially in the opposition ruled states. They should read the judgment given by the Supreme Court 2 days back to back, every letter, and they should follow that judgment in letter and in spirit, because they don't have a choice. And when Mr. Tathagata Roy says that he has referred it to the President, when it is in the concurrent list, even if it is in the concurrent list, only if there is any central law, union law, which is against the state law, that legislation could be referred back to the President. Otherwise, until there is a union law, that is, the state law will prevail. This is the elementary legal principle, and I think it is wrong. Now, the question is this: the governors are not elected. They are the only constitutional functionaries who are appointed, who don't require any other qualification. The President is elected. Everybody else, a qualification is prescribed. There is no qualification that is prescribed for a governor except that he should be an Indian citizen and of 35 years of age. The expectation was that the union government will appoint people with dignity, people with decorum, people who will uphold the rule of law and the constitution. But what is happening?
But Saravanan, is it your contention that governors should just be merely a rubber stamp giving assent to every bill that a legislature passes?
Yes, Zaka, you are right. Governors are mere rubber stamps. They are postmen and yes masters. They don't have any other role. This is what the Supreme Court has said now.
May I respectfully beg to differ?
Yeah.
There have been instances, multiple instances of dissolution of assemblies, which governors have rubber stamped. It has gone all the way to the Supreme Court, and the Supreme Court has struck it down. So I don't think we need rubber stamp governors. But be that as it may, I think I take your point. Let me ask YG Madhuvanti, and I'm going to quote.
Let me finish this.
I'm going to quote.
Zaka, let me finish this.
Okay,
Give
quickly.
me 10 more seconds.
Quickly, 10 seconds.
10 more seconds. Yeah, see, the problem is when the governors act as a super CMs, they want to withhold. See, they can't withhold. If they withhold, they'll have to send it back. That is what the Supreme Court has said. But what the governors of the BJP are doing, they are sleeping on the bills. They are putting it beside their pillows and sleeping after getting paid extravagant money.
So let me ask YG Madhuvanti, and I'm quoting from the Punjab order that came out yesterday by the Supreme Court, that the governors can advise reconsideration but must immediately send back the bill to the legislature. The governor's advice is not binding on the legislature. The legislature alone will decide whether or not to accept these recommendations. And the most important thing that the court said in its order yesterday, a virtual veto by the governor over legislature's functions is against constitutional principles. So the court is very clearly laying out that yes, once the governor can raise a request for reconsideration, but the second time, if the bill is sent back to him, he or she has no other recourse but to give their assent to the bill.
So, good evening, Zaka, and good evening to my fellow panelists here. I don't think we can compare and cut and paste what has been told to Punjab to Tamil Nadu here. I think we've already had this discussion a couple of months ago on your same channel. Bills that the governor has not yet passed his assent on in Tamil Nadu are completely different from what has happened in Punjab. Let us be very clear that some of these bills, rather most of these 10 bills, so-called bills that are being spoken about, are asking for the governor not to be in the post of chancellor, to remove himself from that post and to make the Honorable Chief Minister of Tamil Nadu the chancellor and appoint vice chancellors of their own will and wish. Now, how is this allowed as per the Constitution of India, which has been framed by Shri B.R. Ambedkar, whom the DMK worships as their godfather? I really don't understand. And trying to make this a political issue, I think the governors of any state are beyond politics. They are not puppets and they are not answerable to the political party, but they have to follow the constitution and the system. And if you think that a governor in a state is only there to give you tea parties and luncheons, that's not the case.
But ma'am, the DMK's contention is, for example, this online gaming bill that has been, that the governor has not given his assent to. What is the problem? It comes under the state list.
Why is it that the DMK government is not answering my question? How can you make the Chief Minister of the State Chancellor and appoint your own set of Vice Chancellors?
Zaka, I'll answer that.
Okay, quick rebuttal. I've got Kapil Sankla and Salman Sood also reported.
Zaka, the Constitution did not appoint the governors as Vice Chancellors. They have been appointed as Vice Chancellors by the statutes of the state government. And any elected assembly has got the full right to amend. They can make anybody as chancellors of the universities. It was made by a statute and we want to amend that statute. The governor has no business to withhold it, stating that I am giving my away powers. Who are you? What way you are associated? You are not even worried about the welfare of the people of Tamil Nadu.
No, but Saravanan, every state in universities across states, in Tamil Nadu, in Kerala, in Bengal also, this was a big issue some time back, where governors are chancellors of universities. There have been clashes, particularly on appointments, more than anything else, on appointments between governors and state governments. Eventually, you find a way out. The solution to that problem is not removing governor as the chancellor of state universities. The solution to that problem is to arrive at a consensus, to have an expert committee and look at competent appointments and make those appointments, not to remove governors as chancellors.
No. See, that's what, Zaka, let me